Yo, we want to thank you guys for checking us out every day. Your number one spot for entertainment news. You already know, like we always tell you, don't forget to hit the like button, hit the share button, let us know what's up. And
the Vybz Kartel case. After many months of legal maneuvers and years behind bars, a future outside of a prison is now a real possibility for the international dancehall star and his co-defendants. But there's one more hurdle to overcome.
The Judicial Committee of the Privy Council has unanimously concluded that the appeals should be allowed and the appellant's convictions should be quashed on the ground of juror misconduct.
International dancehall music star Vybz Kartel, real name Medija Palmer, and his 3 co-defendants have been behind bars in Jamaican prisons since their arrest in 2011 for the murder of Clive Lizard Williams, whose body was never found. They were convicted in 2014 after the longest trial in Jamaican history. In the trial's final days, one of the jurors was suspected of offering bribes to the other jurors. Instead of dismissing the case, the judge allowed it to continue, but the Privy Council found that was wrong. For Kartel's attorney, Isaac Buchanan, it was a huge win.
A statement was made by the question of his conviction, and that is where we are at. Yesterday, Mr. Palmer was a convicted felon. Today, he is an innocent man.
In a statement sent exclusively to my Instagram, Vybz Kartel says in part, "I am now back to being an innocent man in the eyes of the law. A grave injustice was done to me and my co-accused in the original trial." Instead of ordering his release outright, the Privy Council referred that back to the Jamaican Court of Appeals.
They have 2 options. One, they call for a new trial, which means we will start this process all over again from the beginning with a new jury, perhaps new attorneys for the defendants, perhaps a whole new set of facts and scenarios even. Or they will release Vybz Kartel and the co-defendants.
The level of interest in the case has been off the charts, says Yasmin Peru, a reporter with the Jamaica Gleaner.
This is not something that was confined to the entertainment section of the news. This was breaking news on every level. And Kartel's popularity, his global influence would necessarily dictate that these are the kinds of steps that we take.
And we are here to provide special coverage of the handing down of the judgment at the Judicial Committee of the Privy Council in London of the case involving Vybz Kartel and his 3 co-convicts, Kahira Jones, Andre St. John, and Sean Campbell. With me in studio is Dion Jackson Miller, our legal correspondent, host of All Angles. Dion, this is a very important case. All Jamaica is literally on tenterhooks waiting for this judgment.
Yes, I mean, I don't think, I was trying to remember in recent years if I've ever seen a verdict so eagerly anticipated, and I honestly can't remember.
Right, and briefly, if you just tell us again, what are the options, what are the likely outcomes that the Privy Council, the law lords would decide?
Okay, well, broadly speaking, there are 4. So at the 2 extremes, one, the Privy Council could decide to allow the appeal, meaning that in that situation, the appellants, Vybz Kartel et al., would go free. At the other extreme, the Privy Council could decide to uphold the conviction, what they call to affirm the conviction, in which case the status quo would remain, nothing would change, Kartel et al. Would remain in prison. Then you have 2 other options which are more nuanced, and I think people generally expect that we're going to be hearing one of these 2 options. It could be, we hear a lot of people talking about a retrial. Now the Privy Council itself is not going to order a retrial. They don't operate like that. Okay. What they would do is to remit it, send it back to the Court of Appeal for the Court of Appeal to quash a conviction and decide if there should be a retrial. And there are a number of issues that they take into consideration when they're making that decision, which I'll come to in a moment. But the 4th option is people may have heard lawyers talking about the proviso and applying the proviso. Now, there is a provision in law, the statute that operates, or that is the, what should I say, is a law under which the Court of Appeal operates, that allows the court to find in a particular case that even though there has been an irregularity, even a material irregularity, they can still uphold the conviction by applying what's called the proviso. In other words, the court can say, yes, there was a problem in this case, but we still think that the evidence was so strong, and there's a particular test that is used. They say that if a jury that's properly directed would still have convicted on the evidence that was presented, then the conviction can be upheld. And one of the important issues here is, of course, the interest of justice. So the courts have said, for instance, the Privy Council said in a case called Dennis Reed against the Queen that they look at the fact that whether it's in the interest of justice that people who are guilty of serious crimes should be brought to justice and not escape merely because of some technical blunder by the judge in the conduct of the trial and his summing up to the jury. That would play on their mind if they're trying to make the decision as whether or not the matter should be sent back for a retrial or sent back to the Court of Appeal, I beg your pardon, for them to decide if there should be a retrial, because they're going to look at the circumstances. You know, is this a very strong case? Is it a heinous case? Is it one that really and truly, if there was a problem, it should be? So
in other words, this proviso rule would come in the fact with the telecommunications, the tampering of the cell phone, where the voice notes were pulled from, and whether or not the issue of when the bribery of the juror came up, and the argument that it should have been dismissed, that they would say, yes, those were missteps, but based on the evidence, we'll still...
Well, as we saw when we watch the hearings, really and truly, I mean, we think it's going to come down to the issue of the juror. And just to remind our viewers that there was a juror in the matter who had attempted to bribe the forewoman. And the question was whether, in fact, this juror should have been dismissed from the panel and the case continue without him, or whether, in fact, the entire jury should have been dismissed and the case started all over again. And the concern was whether, in fact, this, as I call them, the tainted juror, the bent juror, whether the rest of the jury, having heard about the attempted bribery, would then have come down extra hard on the defendants, even though there was no link before the court that the defendants had anything to do with the bribery. So the concern was that the jury maybe would have heard, wait, hold on, them they try bribe somebody? No, make we come down hard, let us convict.
Or that's a sign of guilt.
That was the concern. So and you heard, for the people who watched the Privy Council hearings, that the judges were very concerned about this. This was what they spent most of the time on. This was what they were asking
a lot of
questions about as to whether a fair trial, because that is the bottom line, was a fair trial conducted for Kartel and the others in the circumstances of this tainted juror having still been sitting with the jurors, the other jurors, having gone into the jury room and been a part of that deliberation. Could this process still have been said to have been a fair trial for the defendants?
How about the other point, the third one, that it was wrong to invite the jury to reach a verdict late in the day, given the special circumstances in the case?
We heard that as a point, and somebody was asking me today, why is this a big issue? Now, one of the issues is that, remember, our jurors don't have a reputation, don't have a habit of sitting for 5 hours, 8 hours, 10 hours. You know, the average is maybe 2 to 3 hours. In this particular situation, what had happened was that the jurors had been told to retire just before the time at which court would normally have ended for the day. And the concern was here, hold on, are the jurors going to feel rushed? Are they going to feel, look, no man, me tired, me want to go home, me could just come to a decision? So the matter would not have been properly considered. Again, I mean, we heard some questions, but again, I really think the gravamen of the Privy Council's concern was this issue of the bribery and the juror who participated in that.
That you think it will pivot on that?
I really do think so. The whole issue of jury management, and by way of interest, that same juror, in fact, had been the subject of a discussion in judges' chambers a little earlier in the trial because he had had contact with one of the defense attorneys, and the jury is not supposed to have that kind of contact. So there had been a discussion in chambers, but it had been decided that the matter could go ahead.
Whole nother frequency, bitch, OD, what the fuck is a mug? Nigga be fake, won't leave him snuggly. He on the cover, then fuck it, we tucking a minute. It's on in this stuff, nigga, fuck it, you said. in the name of the source. Bismillahirrahmanirrahim. We flipping niggas out the porch. Niggas in Paris, somebody J version, boss whole Jane Harden, but they think they the highest. We locking them up, you get caught with the smoke, get your flame darkened. They shoot a shot, but I ain't far. Just fuck around, hit the same target, back to back.